Hello, everybody. Welcome back. Welcome back. Thank you for staying with us. Hopefully you are recaffeinated, resugared, ready to go for Cheryl Dowd. She is someone who I read all the time. I am excited to be able to introduce her. I participate from remote. I'm a little bit of a closet stan of hers. She serves as the Senior Director for the State Authorization Network and WCET Policy Innovations and a Cyber Fellow for WICHE, W-I-C-H-E. Dowd directs the activities and research to manage state and federal regulatory compliance requirements for the out-of-state activities of the member institutions. Additionally, she serves the overall WCET membership in addressing emerging and special regulatory issues related to digital learning in post-secondary education. She earned her JD from the University of Richmond, her MS in criminal justice from Bowling Green State University, and a BS in political science from James Madison University, the Dukes.
That's right.
Go Dukes. Super relevant to all of us here, especially this week, especially next week. I am looking forward to hearing what she has to say. So thank you.
Oh, thank you. I am really excited to be here. When Alex phoned and said she had heard my presentation at OLC last fall, I was like, wow, you did? and she was asking me about, an update and providing something similar to you all today about what's going on. There is so much going on. And so when I start to get cynical about what so much going on entails, and I can get cynical, I start to think about the fact that we're talking in our space about innovation, and innovation is always ahead of the law. So how many of you all are Downton Abbey fans? Anybody a Downton Abbey fan? Okay, great. So Cousin Matthew, right? Okay, Cousin Matthew, end of season 3. What happened to Cousin Matthew? He fell out of a car. It was a new, this is post-World War I car. What hadn't been invented yet? Seatbelts. So this is so relevant to what we do. So we are creating new tools. So naturally, there are guardrails being put up and other types of things to help protect students, in what we're going to talk about a bit today, the federal financial aid program. So just so that you're aware, there are reasons for this. And why does it seem like there's so much these days? Is because you all are doing really good and creative work. And so now the regulations are catching up. That's what I tell myself when I'm getting cynical. Okay, so I appreciated that introduction. So who is SAN? Okay, so SAN is the State Authorization Network, okay? So some of you may be familiar with WCET, the WICHE Cooperative for Educational Technologies. They're our parent organization. WCET created SAN back in 2011, right after the release of the first iteration of the State Authorization of Distance Education Regulation, when we all learned what? There are requirements when we offer activities in another state. And so we realized that states needed support and institutions needed support. So we created another membership group. So there's the WCET membership group and the State Authorization Network membership group. Work very closely. Some of you all may have heard of my boss, Russ Poulin. He is Batman, I am Robin. And we work on these policy things. And so that's who the State Authorization Network is. So it was an acronym and an acronym when I said that about WCET, the WICHE Cooperative for Educational Technologies. Okay, so what's WICHE? There are 4 higher education regional compacts in the United States. Okay, WICHE is out west. Funny enough, WICHE is where WCET is housed, but that's a national organization. Actually, they boast of having a few out of country. I think there's one in Canada. So, kind of makes them international. There's probably more, and Russ will kill me for not knowing the other countries, but it's primarily a United States-based organization. And SAN's the same way. We have institutions in all states except for Vermont, Kansas, and Hawaii. Don't tell me why. I have no idea. So that's who SAN is. We'll talk about statutes, regulations, and guidance. I want to distinguish what is currently in regulation, what you're currently responsible for doing, from a new rulemaking that is going to affect some of those things that you're currently doing, and also what is going to be final regulations effective this coming July. And then we'll talk a little bit about AI after that. And then after that, I've made sure that if I talk quickly, we can get to Q&A. So I know I want to take questions from you all about the topic area of your most interest. So again, SAN, State Authorization Network, we work with institutions and agencies nationwide to help them know what the requirements are for their institution to offer interstate distance education and those ancillary things that go along with that. And so we work very closely. We provide training. We provide analysis. It's our goal to try to make it conversational so people understand what this legalese turns into for implementation purposes. So without further ado, I will move forward. Here's relevance. Okay, since lunch, the House has said that they would agree to, they voted for a continuing resolution to go past March 1, but only for a week. So there's a continuing resolution, short-term funding extension that House has voted, Senate hasn't voted yet, but they said they were going to agree to it. So we should have a continuing resolution, certainly in time for the March 1 deadline that came from January. So there are several entities that are subject to the first deadline. It's another dual one. So then education, and 80% of the federal government, including education, is that second date. And they've moved that to the 22nd. So now the new dates are the 8th and 22nd for a continuing resolution. So March is still going to be a hot month. Okay, so in terms of responsibilities of the institution, I want to make sure that you all understand the language. So as somebody who went to law school, I get kind of nerdy about language. Words mean something. And so I get kind of twitchy about, words being used correctly. So you can't merge really some of these terms and have them mean the same thing. So starting with a hierarchy. So we have, and we're talking today mostly about federal. So please be advised, states have rules too. So you're responsible for state rules, but we're going to talk about federal primarily today. So we've got federal statutes, laws created by Congress, typically approved by the president. Then we have federal regulations. So the executive agencies can develop rules, administrative law, that is to implement the federal laws. So those regulations are binding and have the force of law, just like a statute. I say that to distinguish from something called guidance. So if you ever hear people use words like guidelines, guidance, dear colleague letter, these are things that are put out as helpful information, typically from that agency. So we're talking about the Department of Ed today. So the Department of Ed puts out a dear colleague letter is what we often hear. And that dear colleague letter does not have its own force and effective law, but it's the department's thinking about what the words mean that are part of the regulations that they've put out. So if any of you have read new federal regulations when they're announced by the Federal Register, oh my God, is that mind-numbing, because it could be hundreds and hundreds of pages. Usually in final regulations, what they're doing is they're sharing the responses to public comment. So it's hundreds and hundreds of pages, and then some assessment of the financial impact, and then the regs themselves. But that's guidance at the beginning. That's what the department thinks about it. That's not the law. It's not legally binding itself, but that's how the department would want to enforce it. So I just wanted to make sure that we know the distinction, because sometimes I hear when people are referring to regulations, they'll say guidelines, and I'm like, no, because guidelines have some sort of iffy effect to it. And so they're more along the lines of, this is the best practice, as opposed to something having a legally binding responsibility. Okay, so I said all that about guidance because what happened in the last year? We've had two different guidance aspects that were released in 2023. And the first one was at the bottom. I'll go in reverse order there. The first one was the third-party servicer guidance. Did anybody else's hair go on fire when that got released? Okay, well, yeah, our hair was on fire too. And what did the department do? They extended it for a month. And then they went and decided, you know what, we're going to pull it back and we're going to revise it and send out new. So last spring, we learned that they intended to do that, and they removed previous guidance that had banned international companies from being third-party servicers. So we're still waiting on that guidance. They went to, so the Department of Ed was a speaker at NASFA, a financial aid professional group, and they said that the new guidance would be coming soon. It's February, haven't seen it. That was June when they said soon. So we do know that 2U is involved in a lawsuit with the department, and they have updates in that within that lawsuit. And in theirs, one of the updates said the department was indicating it would probably be 90 days into 2024 before we would have new guidance. So we are kind of expecting it this spring. Not sure what it will say. We think that's going to focus more specifically on OPMs, but we'll see when it comes. But that's expect that in the spring, and we'll be providing analysis for sure. And then, of course, the first one at the top of that sheet came out after the third-party servicer guidance, and that was about the accreditation and eligibility requirements for distance education. And I only point this out to say that during COVID, there were accreditation flexibilities, and the department was indicating that the national emergency had ended and that it was going to be X number of months after the national emergency ended that everything would be back in place. And so they were announcing that. So the COVID waiver had ended. They're actually talking about accreditation eligibility requirements for distance education in the rulemaking that's going on right now. We'll get to that in a minute. A little bit of a spoiler alert that will address that. Okay, so that's in guidance. And so I make that distinction again to say that was guidance, and the department is saying, oh, you know what, let's put this in regulation about accreditation. So that's good, because then they'll put it in regulation, and then it has more formality and legal weight. Okay, so what are you responsible for right now with distance education? These are the 5 that, you know, pop up to us more specifically. There are others, but these are important ones. The first 2 I'm going to go in depth about. So let's jump down to the third. The third is where to file complaints. Your institution has been responsible since summer of 2011 in institutional information. So your financial aid office should know this area. So the expectation there is that the institution is providing the state agencies and accreditors contact information so that students know where to provide a complaint. And so some people didn't realize that that's still a requirement, but it is. Misrepresentation, I think that one is obvious. I think the thing I would like to point out there is sometimes marketing divisions at an institution can get excited about things. It's a good thing to be working with, collaborating with, so that they know the parameters of what's being offered out there, so that it's not exceeding what your actual expectations should be. Excuse me. And then finally, student identification verification. What this has to do with is that the institution has a responsibility to verify that the student who has signed up for the course is actually the student participating in the course. And part of that in this subsection H is about the using of proctoring. And so sometimes there's an additional cost if you're using a tool or you're requiring them to go find a proctoring service in person somewhere. The purpose of this is to say that the institution has a responsibility to let the student know of this extra cost before registration. So learning of it in the syllabus is too late. And so when this first came out, institutions were going, well, we were putting it in the syllabus. That's an expectation that's too late. So the institution is to provide that prior to registration. It's transparency. It's letting the student know before they register for the course. Okay, federal regulations for state authorization. This regulation was first raised in 2010. There's a long history. It's really kind of like a soap opera, because there's been regulations. I've also called it federal Groundhog's Day, because we would have a regulation, then it would be vacated. They'd have a rulemaking. They'd put something forward. There was another delay. Then there was another vacating of the delay, another rule. It just constant drama. But now, since July 1 of 2020, we have this regulation that I have here. And it's tied to federal financial aid. And what it means is that the institution has a responsibility to be in compliance with state laws where your students are located. And you can do that in one of two ways. You can do it state by state. Those of us that remember the days before reciprocity remember doing that. I was just talking about it a few minutes ago. I was doing that work. We had red states, yellow states, green states. Actually, I even had striped states because you could do a little bit. And so they said it looked like fruit stripe gum. Am I aging myself by saying that? But yes, so it looked like that. But it is important that an institution know where their students are located. And part of the regulation indicates that your institution should have a process in place that shows how you are determining where your students are located. And it's supposed to be documented and made available to the secretary upon request. And so that's since July 1 of 2020 that you are to have this process in place. It becomes really important with the things that are coming out now because it's only getting to be more of an issue. So it's really important to check back at your institution that you have a process in place to determine the location of your students. We call it a defensible process. That's our term. And it just means that the department has not indicated how you are supposed to do this. They say it's based upon the institution's processes and procedures. So you have the ability to address what is important for your institution community, but you should have something that is documented and used consistently at your institution that then upon an audit, you're able to show that you have been applying it in this manner. And so we call that a defensible process because you're able to do this and show that it has been working for your institution. Professional licensure. So back in 2020, they came out with a rule that requires an institution to be transparent about programs that lead to a license. And what they required of the institutions is a two-part requirement. So it was to provide public notifications and then under certain circumstances, direct notification. So I decided to put it into 4 elements when I look at this citation for a federal regulation because it addresses all modalities and it's specific types of educational programs. These are educational programs leading to a license that is required for employment in the occupation. Okay, so some licenses aren't requirements to be able to be employed. This is all about being employed in an occupation. So it's the educational programs that lead to, and I should indicate, a state license that is required for employment in the occupation. And so then we come to these public notifications. Well, what's that? So the public notifications, the department indicated that you're required to have 3 lists, and you're to put every state and territory into one of those 3 lists. And the lists are curriculum meets state educational requirements, doesn't meet, and have not made a determination. So they said that you should be providing this, make available is that institutional information terminology. So you should be providing that for your students. And then under certain circumstances for a prospective or an enrolled student, they would be receiving an additional notification directly to them about their program. So a prospective student is when the curriculum does not meet or you haven't made a determination. Enrolled student, it's if there's a change and you're letting them know there's been a change within 14 calendar days of knowing that determination. Excuse me. Okay, so more fun with regulations. So right now there is a rulemaking going on. It started in January. And rulemaking, that's how the department creates the rules. They bring key stakeholders together. The department gives proposed language, and the goal is for the negotiators to collaborate. That's the optimistic goal, is that the negotiators are all collaborating to come up with final language that they will vote on. And if they reach consensus, which means nobody is against the language, then that will be the language that will be put in proposed regulations subject to public comment by everyone for a 30-day period typically. And so they're meeting right now for the institutional quality and accountability. The student loan debt relief, that's the loan forgiveness. That one popped up last summer due to the Supreme Court voting down the Biden plan. So the department was addressed by the White House as using the regulatory process to come up with a structure. So they met, and you may have seen there was some, information in Inside Higher Ed that said, oh, they're going to meet another week to try to reach consensus. They did, and that just happened. So we will see probably a new proposed rule. The department has indicated May. So we'll probably see a new rule about loan forgiveness in May. Well, last winter, they released the intention to have a rulemaking for the institutional quality and accountability. It got sidetracked, so they could do loan forgiveness. So it meant that instead of meeting in the fall, it's meeting right now. Its final week is next week. Issues in play have to do with recognition of accrediting agencies, the whole Florida, North Carolina thing that's going on right now about having to change accreditors, plus multiple other accreditation issues as well. Institutional eligibility, this is a big one. Reciprocity is in danger. And I don't think that I am overstating to say that, because if you read the proposed language by the department, they want states to be able to enforce all of their individual laws where an institution is located. And if that's the case, that goes against the principles of reciprocity, which was the point of having a uniform structure of oversight of institutions and one set of requirements for institutions to comply with in order to be authorized and renewed in each state. So that is under fire right now. They're also talking about distance education pertaining to clock hour programs. They want to remove asynchronous clock hour programs from being subject to Title IV aid. So we've written about it. These slides will be available to you. These all have hyperlinks to some of the writings that we do. We write something called WCET Frontiers, which is a weekly, sometimes more than a week, blog where we address timely issues. So it's not just about policy, although we do write a lot about policy, but we also write about practice. So you'll see other things about other types of topics in the digital technology space. But I do want to make you aware of this new rulemaking and how the rulemaking process works. So rules that come out as proposed get a comment period. Lately, it's been 30 days. It used to be 60, but I've seen department pull back on that. It's usually 30 now. They have to release the regs as final by November 1 to meet the master calendar. And that's because of financial aid. So if they meet it by November 1 as final, then they are effective the following July 1. So things released this coming November 1, 2024, like we think the loan forgiveness would be effective then July 1, 2025. But the Department of Education on the OMB, Office of Management and Budget website indicates the unified agenda for all executive agencies. And there we see that the department speculates that they will release proposed regs on this rulemaking going on right now in October. So doing the math, I can't see how they can get a 30-day comment period in and have new final rules released by November 1 of 2024. So that would mean that the regulations would not be able to be effective until 2026. So these rules and these dates are really important and key to what is going to be happening. We could see a change in administration. We saw that before at the end of the Obama administration. They released final rules that, under the new DeVos Department of Ed. They were deregulating. And so they reviewed these and they went to they went to delay the regulations that were supposed to be effective in 2018. So I don't know. We'll see. We'll see what's happening. So just to be aware that this rulemaking is really important in regard to distance education, and somebody at your institution really should be keeping an eye on it. We really encourage that an institution have the ability to share with their senior leadership. Also, if they have a governmental affairs group at the institution, to advise them. It will take letters from the legislators in the states and federal for this to get a look to make sure that this is something that should go forward. What are my concerns about reciprocity? My concern is that the folks, the negotiators that are promoting the all states be able to enforce their own, is that there are half a dozen states with really strong rules. There are 21 states that do not have oversight of out-of-state institutions for purposes of just distance education because they don't have physical presence. So while this may raise the bar for consumer protection for some students, it won't raise it for all, and actually it will drop for some. And so we think that and I say we, WCET, would be inclined to say, well, let's strengthen reciprocity and strengthen consumer protection within reciprocity so that it's for all students and not just for a few in a few states that have stricter rules. The reciprocity was brought together by, in most states, it was voluntary, but in most states it required new legislation signed by the governor to join the reciprocity agreement. So we have 49 states that the legislators and the governor were involved in joining reciprocity. So it's voluntary. If states don't like it, they can leave. It's not something they have to stay in. So, I think that's a point to address. And if you think about it too, those of you that were doing the work like I was before reciprocity, there were states that had difficulty with bandwidth to be able to address all of the institutions that were serving students located in their state. My example was the state of Maryland. I had submitted for Maryland. I had not heard the approval, and yet we were supposed to submit for the next year for renewal 6 months before the expiration date. And I hadn't received it yet. So I submitted without having received from before because it was taking so long for states to be able to respond. So it is a difficulty for state bandwidth. I've talked to state regulators. They are concerned about being able to manage the onslaught of institutions that they will have to serve and review should reciprocity go away. Okay, enough on that one. Okay, so new final regulations. This is exciting. So these are the regulations that were released in October of 2023. That meant they met the deadline. So they met the deadline. So these things can be effective this coming July. So these titles, sometimes you don't realize, how they're going to affect you based on what they're named. So first, gainful employment. I think we all kind of have that one. I've got a bunch of resources to share with you on gainful employment. But when we look at the ones that were released later in October, financial responsibility, administrative capability, certification procedures, ability to benefit. So Cheryl, why is certifications in red? Because that's where you're going to find new rules that raise the bar when you are serving students that are in programs leading to a license. So that's what I'm going to highlight here. And so when the department released their intent to rulemaking, they said, oh, we're going to do certification procedures. And we went, okay. We didn't realize until they sent out the first issue paper that they were going to address professional licenses. And so what did not happen was there was no one from licensing communities that were aware that they were going to be having this rulemaking on these points, and were not part of the key stakeholder unit that was addressing the regulations. Keep that in mind. So what is certification procedures? This is the contract. This is the agreement between your institution and the Department of Ed so that you can participate in Title IV HEA programs, so federal financial aid. So you have to have your programs approved, and you have a set of rules, a set of items that your institution certifies that they do in order to participate in Title IV. Yes, the institution is responsible for being in compliance with all the federal regulations, but this contract, these are the ones they really need. And it's that list that you have to make sure that you're affirming that you are doing these things. And so there was discussion of who the signatories would be for certification procedures, but it came down to a number of new things that an institution must consider. And so down here at the bottom, I include a woman's name who has actually been really responsive. This is the contact the department gave in the Federal Register about the issues and said this woman, Vanessa Gomez with the department, would be the person that if you have questions about anything within the certification procedures issue, that you can reach out to her for clarification. I can't say enough about how responsive she's been, and I appreciate that. So I give you her name, her email, and her phone number, and she is responsive. So I think that's wonderful. So I'm very grateful for that. Okay, so related to professional licensure. So remember I was talking about notifications. Okay, so that's not enough anymore. So the department has decided to raise the bar for offering programs that lead to a license. Your responsibility after July 1 for any new student enrolled on or after July 1, your institution must satisfy the state educational requirements where they're located. And for students that are enrolled in distance education where they are located at the time of initial enrollment. So that's an issue, and the department has made some clarifications in email. So again, not binding law, but they've made some clarifications. They believe that even one distance education course trips this, so that your institution would be responsible for satisfying state educational requirements where that student is located. So what does that mean in practical terms? Let's say you're an institution that's on a state line. You offer a program leading to a license, and the student is doing in person for the program, but pardon me, they are taking an elective or a gen ed by distance education, and they happen to be located on the other side of the state line. That triggers the responsibility here to satisfy state educational requirements where the student is located. We push back on this. We'll hear from the department more. I can tell you that the department has indicated that the questions that have been provided to Ms. Gomez are instructive for them to create an FAQ, which is a guidance document that we hope to see before July 1. So I'm just telling you what the department has indicated thus far. So if you have students located in another state and the institution does not satisfy state educational requirements, you are not to serve that student in that program where they are located. So it's for students enrolled on or after July 1 of 2024. So what does this mean for your students that are currently enrolled? The department is not making this retroactive. They don't want to cause a problem for students already in a program, but for students enrolled on or after July 1, you must satisfy the state educational requirements where the student is located at time of initial enrollment. What if the student moves? The department indicates that you are not responsible if the student moves. What if the law changes? The department has indicated you're not responsible if the law changes, but there are notifications, and we'll talk about that in a minute. Notifications still are in place, so it's transparent to the student that there's been a change, but the institution is responsible for time of initial enrollment. And that was part of that rule I was talking about before about student location. So check your student location policy and make sure that you are comfortable with where your students are at time of initial enrollment. And then you'll see that it indicates if there's been a change. So that should be part of your policy as well. But the department's very focused on this. They gave a plan B. So their proposed regs indicated only where the institution's located and satisfying where the student is located at time of initial enrollment. They gave a plan B, and this was due to public comment. Public comment's always good. It helps inform the department of what the practical aspects can be. They offered a plan B in regulation that says, or where the student attests they will seek employment. And so if the institution can meet state educational requirement where the student attests they will seek employment, then you may serve the student. So New York institution, you have student in Pennsylvania, that you don't meet state educational requirements in Pennsylvania, but you do in Connecticut. And the student says, oh, well, I'm only here temporarily anyway. You know, my spouse is military or whatever. I'm going to be seeking employment in Connecticut, and you meet state educational requirements in Connecticut, then you may get an attestation from the student that they intend to seek employment in this other state. Now, caveat, document, document, document. That is going to be an important piece of information to have, this attestation, and the department has indicated that the attestation document, whether that be hard copy or electronic, is not sufficient on its own. You would need to show that you have processes at your institution that you've informed the student adequately about what their options are, so that it's not just some sort of quick electronic thing that the student just that you put in front of them and say, here, sign this. That it shows that the student was able to make a fully informed decision, and this was the decision. The department has indicated that in the event of a borrower defense repayment claim, that they would like this information. So be aware of that. So if you use the attestation, it's two pieces, not only the attestation of the student, but also what's your process to get them to the attestation.
Sorry, in real practical words, would this mean that if perhaps teacher certification isn't, would that be included? Okay.
Yeah.
So if you're an institution in Illinois and you've got a student from Connecticut and your program does not meet the requirements of teacher certification in Connecticut, you would either have to not serve that student or tell them very clearly that this program will not qualify you to teach in Connecticut?
Yes. And do you intend to stay there?
Okay.
So if they intend to seek employment in another state for which your institution can meet state educational requirements, then that is considered as satisfying state educational requirements. Let's think about this. This is all about connecting the dots to employment. The department is very concerned about institutions providing or a student completing the education and having a worthless degree. They use that phrase because they want the student to be able to complete the program and be employed. Because if you're employed, you're less likely to default on your loans, right? So we're trying to get the student connecting the dots. Now, here's something else the department said. They did this in the guidance found in the preamble. So in regulation, they offer the attestation. But in the preamble, they said, oh, we know that there are professional compacts and multi-state agreements out there that would provide a pathway for a student to be able to get a license. So you're talking about Connecticut. What if Connecticut's rules was that you could get a provisional license, be employed while you complete history of Connecticut? So before, it was a problem because history of Connecticut's not in your curriculum in Illinois. But if you can get a provisional license and start working while you do history of Connecticut, then that is considered satisfactory. So again, document. So I have been working with Council of State Governments, who's been instrumental in the development of professional compacts. The Mobility Compact for teaching is relatively new, but NASATEC has been offering the multi-state agreements for years. So that's an option for teaching. There's compacts for nursing, counseling, social work, multiple, but it's got to be license to license, apples to apples. And so it's going to take handholding from the institution to make sure you're getting student to a position where they can be seeking employment in the state where they are. So you have to show that you're getting them to employment. So we have things in SAN, I'll talk about that later. We have more resources to read more on that because that's very nuanced. But the thing is the institution, do they have the bandwidth to work with students individually to get them to this? Because this is going to be one-on-one to be able to get them to employment if they don't meet state educational requirements where they're located. Okay, so the public notifications didn't really change. I wrote it out this is the language, but I put it in bullet form. It's in paragraph form in the Code of Federal Regulations. But again, designed or advertised as meeting requirements, a list of all states where the institution has determined that the program does and does not meet such requirements. That's a change. So current requirements through June 30 is you have these 3 buckets. Now they're saying the institution's only responsible for providing 2 buckets and only where you've made determinations. Now, if you're serving a student you better have that state in the determination list as meeting it. And if it's in a not meet, you better have that alternate satisfying through attestation or something about the compacts. So the I don't know won't cut it, and you're probably going to keep a mental list or a physical list under your desk of where you don't know, but you only have to publish where you do know meets or does not meet. And they're saying, the department has indicated that if an institution is not enrolling students in a given state, you're not obligated to determine to say anything regarding that state. So when you think about New York institutions, do you have to know what's going on in Idaho if you're not serving students in Idaho? But you probably shouldn't be advertising there. So that's what the department has indicated for the public notifications. And then for direct notifications, it's essentially the same. It does refer back to that program participation citation, but it's basically the same. For prospective students, you're indicating if it does not meet or if no determination has been made, if you have a prospective student. And then for an enrolled student, this is really important. When I was talking before about the department's really focused on time of initial enrollment, this direct notification is going to be really important, so the students can stay up to date on the fact that their program, there's been a change or they've changed location, and you said, well, we met it where you were before, but now it doesn't meet, and here we're being transparent with you about where you've moved. So that's really important aspect to remember. And then the final part of the participation agreement issue was around, kind of had to do with reciprocity. They were saying that an institution where you have to comply with closure laws where the institution is located and where students are located at time of initial enrollment. And they gave some examples of closure laws. But if your institution participates in reciprocity, you are considered having that requirement fulfilled through that. So there wasn't something extra that you would have to do. And if you are in the position of, let's say your institution doesn't participate in reciprocity, then you would be fulfilling it because of all the other requirements that state has. So it really didn't have the effect that I think the department was looking for when they first were talking about it in winter of 2022, because in winter of 2022, what they were saying is comply with all state laws, consumer protection laws. And so we were like, well, what does that mean? And then they whittled it down to in the proposed rules, and then they whittled it down again when it came to these final rules last fall. And the point was in the Federal Register is that we read the department indicated, we're aware, states have different rules. We know that we're not regulating reciprocity here. We're just saying that, these closure laws are important. So, but we recognize that states will enforce what they want, what they intend to enforce. And any state that is a part of the reciprocity agreement has agreed they will not enforce the additional state laws. So if they wanted to do that, they would have to leave reciprocity. So no states have challenged that yet. So we're considering it as reciprocity is fulfilling that requirement. I promised that there would be resources. So I provided two things that we wrote in the first two items, and then NASFA and ACE both wrote some good write-ups about the rules in regard to institutional and programmatic credibility. And then I promised that I would provide gainful employment resources. I like NACUA, it's the National Association for College and University Attorneys. They did a good job. NASFA did a good work on GE, and also Thompson Coborn's a law firm with a robust ed division, and I read their stuff all the time and attend their webinars. So you can find there, they have a free desk guide about implementing. And also to be aware, what's interesting too is that the department just released the other day a request for public comment, a 60-day public comment, asking if they thought that the request for the reporting So those of you that follow GE at all, there's like a lot of reporting that's a part of that. And so the department asked the question, can you get back to us about whether this is really what we need? And also could you check what we thought the hours would be to be able to prepare this to see if it's accurate? So they were offering the opportunity for institutions to share what their thoughts were on the reporting. I think they should have thought of that before they made the rule, but at least they're asking now before it's effective. Okay, final thing, just really fast before we take questions, just wanted to talk to you a little bit about AI. And this is mostly a plug for WCET's resources. WCET is doing a lot on this. So just a summarization of federal actions that have taken place, nothing new. However, there is a White House blueprint for an AI Bill of Rights, and it has these items as a part of it. I think this is nothing new as you review that, but that's where the federal government is at this time. And then WCET has certain recommendations. We've got 8 recommendations here. Create clear, well-developed policies beyond academic integrity, ensure learner accessibility, create digital digital literacy centered on AI that includes a discussion of AI concerns such as algorithmic biases, regularly update curriculum in collaboration with industry experts, allocate institutional resources for training, engage as much of the campus community beyond the academic community as possible, including students, create collaborative opportunities for faculty, students, and staff to explore and discuss AI, provide a secure environment around the use of AI that addresses data privacy and security. So these 8 principles have caused WCET to also create the WCET practice webpage on the WCET website. So it's very specific. It's a practice page on artificial intelligence. We've written a couple of WCET Frontiers posts on it. And also there is a framework that is posted on the website. So those of you that are members of WCET, institution members could have access. Some of this is member only, not WCET Frontiers. That's available to anyone who wants to receive their information. You can subscribe on the WCET website. For WCET Frontiers, you don't have to be a member to subscribe. And but if you want to be a member of WCET, then you can have access to member only. And then, as far as SAN is separate from WCET. You are welcome also to join SAN. SAN has a unique situation where we have group membership. So a system office, in this case, you all have over 60. So it'll probably be 2 memberships to be able to create 2 large group memberships, institutions coming together to create 1 membership, sharing the cost of the membership to be part of SAN. And the State Authorization Network also has member-only opportunities. And so you would have a login and you could be able to gain access to all of our materials. So I wanted to take the rest of this time. How much time do I have? I have about 10 minutes to take, or 11 minutes to take questions. Yes, sir. Could you use your microphone, please? I was asked to ask that.
Yeah, so here's a little hypothetical with all these regulations. What happens if Chevron is rolled back next year? And you knew that was coming, didn't you?
Yes. So we're following that too. So what he's referring to is before the Supreme Court, there is something, it's the fishing, it's about a fisheries. But what it is that there is the Chevron deference, I think they call it, for the where to provide for the ability for regulations to be created under certain circumstances. We talked about that to implement. But what we've noticed here is that in this present case is going beyond what was intended by this Chevron deference. And so the Supreme Court is not all that excited about the extent of regulatory authority. And worst case scenario, or most damaging, those were all negative words. But what could happen on one extreme is that they say, you know what, regulations are going away. These executive agencies have gone too far, and we're going to create null and void these these regulations. I don't think they're going to go that far. I think what I was sharing earlier, I have a feeling it's going to be more nuanced in the opinion, so that some regulations stay in place. Because can you imagine all of the executive agencies if all regulations are considered null and void? So I think, my opinion, although the court members that were interviewed seem to not be too pleased with where regulations have gone, I think they also know what could happen if they decided to pull the Chevron deference. And so I think it's going to be somewhere in between with a nuanced response that maintains some things, but we could see changes. I think we'll see changes. Just I don't think it'll be full scale. Is that where you are landing?
With their past performance, I think they'll gut it and throw it back to Congress and say, if you want a regulation, you have to vote on it. You know, past performance is future action.
I hear him, and I have a certain little bit of naivete. And so I will talk about what I expect the department to do about regulations and things. And I have a very good friend lives in this community world who will pat me on, because I'll say, how does this help students? And she'll pat me on the head and she goes, oh, Cheryl, this isn't about students anymore, because we have past performance of what happens from some of these entities. So I speak with folks at ACE a lot. And one of the gentlemen there just recently said to me, because I said this, I was bringing that to him too. And he was saying that the issues that are part of this newest rulemaking, these are not White House priorities. Loan forgiveness was, but these are not in this current rulemaking that are going on. But you have members of this department that when they became staffers at the department had these as pet projects that they promised that they would move forward on. So we see that even if they're not a White House priority. So there is a little bit of history repeating itself, but I still want to remain optimistic that that chaos will not ensue. So, but I hear you. I'm prepared for that to happen in my head. Thank you for that question. Yes, sir.
There's a few questions from online that I would like to bring out, please. The first one came from Brandon. And I think this goes back to your earlier slides pertaining to the rulemaking. Also having to create virtual campuses as an instructional location for 100% distance ed programs.
So yes, that is part of the regulations that are being discussed currently as part of the distance education issue.
Okay, and the other two questions, well, there is actually a fourth one too, but the other two came pertaining to licensure. One individual was curious about the regulations related to international students. And then the other question had to do if it would be wise to get official verification from the licensure oversight body in a state where a student resides for your curriculum.
Okay, I'm going to start with the second one first. The second one had to do with should they get affirmation from the licensing board. I can tell you that in talking with licensing national entities, they do not believe that their state licensing boards have the bandwidth to provide affirmation to all of the institutions who request that their curriculum be reviewed to meet state educational requirements. Now, there are some programs in some professions that actually you get approval, but that's not the case in most. And so I can tell you that for nursing, National Council State Board of Nursing held a meeting since Christmas where the education specialist indicated to the states, do not respond to that question. Instead, point them to our website, the National Council State Boards of Nursing, to review the requirements that have been submitted by the states so that the institution is making that determination, because they're concerned that that would be a liability issue for the states to be able to review not only a bandwidth issue, but a liability issue to review the curriculum and make a determination. Because what if the student changes their structure? What if something else happens and that's out of the state's control? And then the student says, yeah, but you said that the curriculum meets state educational requirements and it was affirmed by the state board. So they are concerned about that. And so I think that the ability to get affirmation from a state board is limited at best. And then the international situation. So we were talking about state licenses. So it really is focused on Title IV and state licenses. So I think that is a distinction from this idea of international compliance.
Right. And then the last question is, and if I say your name wrong, whoever put this in there, I apologize. Naren, could you please share your interpretation about USED's proposed rulemaking, quote, removing the allowance for clock hour programs provided via distance education to be offered through asynchronous learning, end quote, question mark. Does this mean an asynchronous online course will not be considered as being offered via distance education?
That is correct. That is what is being proposed right now. So these two things that she's brought up about the virtual location and then now talking about asynchronous clock hour distance education programs, those are part of proposed language by the department that they have presented to the negotiators to discuss next week, for which they will vote on. Obviously they're trying to seek consensus, and so that means nobody disagrees. But if they do not reach consensus, then the department gets to write the rule. So is the department supposed to be considering the discussions amongst the negotiators? Yes, but the department can move forward as it determines, and then we will see it as part of proposed language when they're ready to release the issues. So it's in the proposed stage. And as I said, what it does is it goes to proposed 30-day comment period. And I urge every single person in this room, if you have any concerns about any aspect, to submit a public comment. If you don't have the authority of your institution to write it on behalf of the institution, you just indicate that you're writing it on behalf of an experienced faculty member, staff member in this field, and share the concerns. And the department, in its final rules, has to respond to all public comments. Sure, they lump them together by type, but they respond to everything. So it is really important if you have any questions. And this is what I was also saying about there are circumstances where you're going to want to reach your government relations people at your institution. And we may need to be talking about if this is really going to be a problem for students. If we see that the unintended consequences are difficult for students, more difficult than the protections it provides, then we need to be talking about it with our legislators. So it is something to consider. It's a balance, right? Because we want consumer protection, but if the consumer protection comes at such a price where the majority of students are affected negatively, then we need to figure out what is a better plan.
Cheryl, just follow up. Would that essentially kill asynchronous online were it to go forward unamended, unchanged?
But that's just clock hour, not credit hour, just clock hour. And so when we were first talking about it, it was a limited number of programs that are clock hour, but it's important because there are some institutions and programs that exist in that level. Yes, sir.
My question was again about the clock hour in virtual campus. And you seem to focus a lot on the asynchronous clock hour portion of that and seem to gloss over the virtual campus. And I'm wondering about that because we were trying to read it as a group of directors of online learning and understand how important it was. Is this a bookkeeping thing that should be relatively easy, or is this going to be an extensive thing that changes what we do with significant regulatory oversight by the establishment of this virtual campus? And so the question really was, can you please tell me it'll all be okay?
So when you read the rationale from the department, what they're worried about is closure. And so what this does is it brings together about a virtual location so that they can treat it for closure purposes. So it is supposed to be administrative things, and it's supposed to be protecting the students in the event of a closure.
Mm-hmm.
So that's the intention.
Okay. And then I had just another question based on what you were saying, encouraging people to write in these comment periods. We have an organization called Doodle, which is our organization that connects all of the directors of online together. And in the last negotiated rulemaking, we submitted one response from Doodle and said, we represent, the 64 campuses in our online learning programs, and here is our response. And I just wanted your opinion on whether we should have done that as that association, as that group, or we should be submitting more separate letters. What do you think would be more impactful to having our concerns heard?
I think it's wonderful that you were able to pull something like that together. That doesn't limit you from also providing personal ones. And so, the more is better approach kind of helps, especially if you're able to make distinctive comments. So not a form letter that's just written out 50 times, but, and what we try to do is share instructive points that people may want to use as they're developing. Certainly student stories. I mean, we want to protect students too, but we also want to protect them from unintended consequences. So what will this do? And also we talk about what can the states do? So when in regard to state authorization, we're worried about state oversight and bandwidth to be able to do this, and that there could be unintended consequences in regard to states. So the whole idea is it is better to have more comments, but as the department did in this last session from the winter 2022 rules, they only published half of them. And so we kind of figured that they must have gotten a form letter, and because it's their discretion to release it. And of course, spam gets dumped, ugly language gets dumped. But if it's a form letter, they're not going to keep. So they had 7,500 submissions, and they only published about half of them.
Thank you.
Sure.
Cheryl, could you just talk a little bit about what the appropriate way is, or I don't know if appropriate is the right word, but how to frame concerns about, onerous administrative burden? Because that's a real thing, but I think some people struggle with, well, how does that help students, right? Because that's that's what it all comes down to. And it, in some conversations, right, I've heard people say, well, we just have to figure it out. Well, okay, but I think it's real. So I'm just curious if you have any recommendation or guidance on how to frame something like that in the public comment period.
Well, certainly, and when we're talking about administrative burden, is it going to cause the institution to have to hire more? And so if that's the case, will the dollars to dollars, start to impact the student? Are you going to have to charge more per credit hour, et cetera? So there could be a financial toll at the institution based on being able to manage the additional admin requirements. So the department is less interested in how difficult it is for an institution, but talking about how this ultimately affects the student is important. And so there's impossibility as well. And so we've shared with the department sometimes when there is impossibility, because they at one point wanted to talk about institutions having approval for all of their programs where the student is located. And we indicated, well, that's impossible because not all professional programs in every state approve the program before a student is participating in that state. So that's impossible. So, it's adding that into the mix.
Teresa, online, are there any questions? We should be wrapping this session up, but I'd want to give chance for the virtual folks to ask any questions.
The last question, Alex, is so ABAT, the engineering accreditation body, has a path that is an online, sorry, my screen jumped. Is an online mode, is substantially equivalent to in-person, open paren to be named the same, close paren. Does this language effectively kill that path?
Well, again, you have to look at, is this required? Is completion required to be able to obtain a license to be employed in the program, when I'm employed in the occupation. And what I'm understanding with engineering is it doesn't necessarily bar the ability to be employed, that there are different pathways with engineering. So they would need, so it's not, I can't give you a blanket answer. So it really kind of depends on the program and, you know, is it one that is required for employment in the state?
Okay. I think we have to
Okay,
wrap it up.
so thank you all very much for your time. Word on the street is there's a group of folks that meet over at the Hilton after dinner.
That's true.
I'm gonna come, if you want to talk more. So, well, you guys are a great audience. I am really thrilled to be here, and I thank Alex so much, you know, for inviting me and Dan to, you know, introduce me. So thank you. You all have been very warm and wonderful. Thanks.
Thank you so much. Thanks, Teresa, for being the moderator for the session. Thank you.